I'm very happy to welcome you all to watch this today. I'm with Neill McCarthy, who's a lawyer here in Australia, a lawyer who works on the Illawarra district of the South Coast, which is just below New South Wales, below Sydney. And he started off his working life as a public prosecutor, but then went into private practice working in criminal law. Hello, Neill.
Hi, how are you, Bettina? Nice.
Very nice to have you here. Neill contacted me. One of the things he raised when he first got in touch was the issue of how much of the working life of lawyers like him are now consumed by the business of protecting men who are facing false accusations of violence, often being used to gain advantage in family law matters. And so Neill, that's an issue that has obviously grabbed your attention in recent times.
Yes, it is an unfortunate reality that there are a lot of applications for apprehended violence orders and apprehended domestic violence orders. It's happening a great deal. It's been going on for quite some time.
Yeah. Now, I think we should start to make it clear that this is this whole idea of violence orders. They're called different things in Australia, depending on which state you're in. The apprehended violence or AVOs, ADVOs. I think we'll just call them violence orders to keep things simple.
Yeah.
But it all started from a very good place of obviously the need to protect women who are genuinely in violent relationships with men who could be very dangerous. And so the laws were changed to ensure some protection for women in those circumstances. Do you want to talk a bit about that?
Yeah, well, the apprehended violence system must be perhaps 3 or more decades ago, when it was recognised that there was a very real need to protect all people, not just women, from threats, harassment, stalking, totally inappropriate behaviour. And it was recognised that in addition to personal violence orders, that's neighbours who can't get on with each other, people that would meet in public places. There was also a special need for the protection of the spouses of violent partners. And that is something that started to take greater and greater prominence in legislation over the years.
But of course, what's happened is it's been now, it has shifted. I mean, we've seen that very genuine attempt to protect women shift into something which has become a real weapon that women can use who are in a situation where they want to particularly gain advantage in a family law case. And that is what's consumed me for many years. I receive hundreds and hundreds of letters all the time from families dealing with this, from men whose whole lives have been devastated by the business of trying to fight off these violence orders and all the consequences that follow from that. Do you see? I mean, you see this. There's been a real shift in how often these domestic violence orders are being used, and the amount of your working life that's being consumed by trying to deal with that.
Yes, look, there's no doubt that things have started to gradually get worse, particularly in the area of allegations that have no merit, false allegations. Things, in my view, started to get worse perhaps about 20 years ago, when the police commissioner issued a standing order that all domestic violence allegations were to be pursued regardless of merit. And then, of course, the Crimes, Domestic and Personal Violence Act was introduced in 2007 and amended numerous times since then to make things a lot more difficult for defendants in these types of matters. Mm-hmm. But there seems to be no doubt that apprehended domestic violence orders are frequently being misused by applicants who make complaints for various reasons, or you could sum them up under the general umbrella of tactical reasons.
Yeah.
There's no doubt that there's a financial advantage to be paid by innocent men. And we have to recognise that the vast majority of domestic violence allegations are made against men. So a small number are made by men, but mostly they're made by spouses of men.
Neill, I mean, the issue is also that men might try to take an order out against their spouse, but they don't always get it, do they? I mean, women are much more likely to be believed. It's a very, in my view, tilted application of this particular law, although it's supposed to work both ways.
It is supposed to work both ways, and in an ideal world it would. But there's no doubt that many men are just reluctant to report abuse that they suffer at the hands of their spouses. And there are probably some men who are simply not taken seriously when they go to the police station to make their complaint.
Yeah, I mean, I hear that all the time.
So do I.
Men who get laughed at when they do report it to the police, men who get told to man up when they call the police when they're being abused by their partner. And of course, one of the things that's happened in recent years is this incredible expansion of the definition of domestic violence from originally being focused around physical violence to including emotional abuse, psychological abuse. Even the threat of violence is enough for you to get an order in this situation if you happen to be a woman.
Yes, I'm sure that's right. And intimidation and stalking and harassment have all been included in the definition over the years.
Yeah. And so what we have is this incredible system where police, prosecutors, magistrates, everybody knows this is happening. And in fact, we've had some good magistrates. How would you describe a magistrate to people in America? I don't know. I think they have the equivalent, do they?
I think some of them do. Magistrates are judicial officers. They're judges.
Local judicial officers.
In a local court, yes.
In a local court. So our local magistrates, I mean, many magistrates have days set apart each week for dealing with these cases. It's become so overwhelming, hasn't it, to the workload.
I'm sure that the AVO lists in most courts are really quite extensive.
Yeah.
And it's not helped by the fact that there are so many false allegations clogging up the system.
Yeah. And it's become a bit of a joke. I mean, so there were some surveys done of magistrates a few years ago in Queensland where they were asked about, these restraining orders being used for tactical purposes. And in Queensland, they found 74% of them said yes, that's happening often. And in New South Wales, it was 90% who agreed that restraining orders are often sought for tactical purpose, particularly in family law matters and being used to deprive partners of contact with their children. And so this is known. This is what everybody in the system knows is happening. And yet, if you talk publicly about this, you get howled down. The feminist lobby has this whole public debate around this issue absolutely sewn up, and anyone who mentions false allegations gets attacked. We have in Australia at the moment still a family law inquiry running where one of our senators insisted that this should issue, a senator called Pauline Hanson insisted that this investigation must include, this inquiry must include this issue of false allegations. And the amount of flack she's got for actually getting that through, and the feminists just rolled out everybody to say no, hardly any false allegations, and it simply doesn't work, and it's not happening. And I mean, it's really quite extraordinary how well controlled the public debate on this issue is.
Yes, well, in my view, it's an open secret across the legal profession that there are many allegations that are false. It has to be borne in mind that I don't want to sound too legalistic, Bettina, but the standard of proof is artificially lowered. A court doesn't have to be satisfied on the balance on beyond a reasonable doubt that an AVO should be made. It has to be satisfied only on the balance of probabilities, which means, is it more likely than not that the order should be made? So there's one way in which the system is rigged. But I wouldn't want to complain about the lowering of the standard of proof. But there are various sections in our legislation which clearly indicate that the system is rigged against defendants.
Mainly men.
Well, yes, most defendants are men in these types of matters. I could list them a couple for you if you like, but there's no doubt that the system is rigged against defendants, and they're at a real disadvantage of defending themselves.
I mean, I'm really hard pushed to think, and you might have some ideas for me, of any other area of the laws where this is happening, that we have a criminal offence with incredible consequences, not just from the violence order, but breaches of the violence order can mean you end up in prison. So this is serious business that requires no evidence. Can you think of any area of the law where there's such a low bar?
No, there isn't any other area of the law where the bar's being so artificially lowered. There is evidence, of course. There has to be some evidence that's capable of satisfying the court, even on the balance of probabilities. But the evidence only has to consist of the word of one complainant, uncorroborated by any other physical or verbal evidence from another witness.
And if the evidence can be, I'm afraid he could be violent. That's not saying he has been violent. That can be enough. I don't know whether that's across the board, but it certainly applies in some areas of Australia. That is sufficient. A fear of violence.
Yeah.
To get it.
I think a little bit more than that would be required in New South Wales. I'm afraid he could be violent, assisted by evidence of him acting in a threatening way would be sufficient, surely. I expect so, and it has been in many cases that I've been involved in. Yeah.
And as you've said, I mean, this can tell me overall about the sort of consequences for men. I mean, this gives, if a woman makes this sort of accusation, it enables the man to be removed from her house, sometimes instantaneously, and sometimes often denied contact with. Go through what are the consequences? Yeah.
Well, some of the harms to defendants of AVO, domestic violence matters, including interim orders, can be that a man can be ordered to leave his home immediately, find somewhere else to live. Where does he go? That's on him. There's the reality that any children a couple might have, a man can be prevented from having any contact of any kind with a person with whom the spouse resides. There's the constant, the need for constant vigilance on the part of defendants, lest they be accused of breaching an order or an interim order, and the legal cost of defending themselves, and of course the constant stress of being involved in a protracted court case that will take many months, possibly up to a year, to be finalized. It's extremely unpleasant to be the subject of an application for an order. An order it's not a criminal offence to have an order made against you. That's not a conviction, but breaching an order would be, and the consequences can be very, very severe, including incarceration.
One of the truly hideous developments recently has been websites set up listing men who have AVOs against them, have violence orders against them.
Yes,
and given that many lawyers advise men to accept that order initially, saying it doesn't have much consequence, and sometimes that's the easiest route through this whole process. The fact that I can look up people I know who've had an AVO against them, and they're all listed there, and so can their potential employers, and so can potential partners. I mean, that to me is a truly worrying development, but it's all part of this current climate we live in. It's quite extraordinary.
I've seen one of those websites. It includes not only matters where there is an order, but matters where there isn't an order made yet, but the defendant is listed in court. It doesn't indicate that it's just there for a mention. It's not there. It doesn't mention that whether there's an order or not. It simply presents somebody's name as somebody who has a domestic violence order made against them, which is completely misleading.
Yeah, yeah. One of the things that I noticed the feminists were arguing recently is, oh, well, you know, it doesn't actually work as a tactic in family court, because judges don't necessarily take that into account in making decisions about custody and so on. But I'm sure, Neill, as you pointed out to me, what happens is if a woman isn't able to get the man removed from the home, and he might not have this all, you know, the family court aspect resolved for years after that, it means he can be denied contact with his children for considerable periods of time, get estranged from his children, etc., etc. And that is what has the consequence in the family court.
Absolutely. It may well be that feminists say that allegations for apprehended violence orders don't work. But the problem is most of the people who make false allegations don't really care about feminist theory. What they want is their tactical advantage. They want to be able to punish the spouse by alienating the spouse from the children. They want to impoverish the spouse by having that person evicted from the home by the police and by causing that person to spend a small fortune in legal costs in fighting off the apprehended violence order, even if the spouse's application through the police is a failure, even if it doesn't work. There's no comeback on that spouse. There's no legal costs because the police represent them for free. And yet the poor old innocent defendant has all of these disadvantages that they have to face.
Yeah.
And experience.
I mean, even if the man could prove he was the primary parent or he was, you know, whatever, he'd been the one caring for the children. By the time these matters end up in the family court, that situation has changed. And even where it is shown that some of these, that there was a false allegation, often the judges will make decisions to leave the children, say, with the mother, because that is the status quo. They don't want to disrupt the current situation that children are living in. I mean, it's to me, it's all sewn up, this whole racket that's going on. But I want to get, Neill, you to tell some of your stories you wrote to me about, some of the cases you've dealt with recently in relation to these violence orders. How about Harry and Janet? Can you tell me about them?
Yeah, well, Harry and Janet were married for about 23 years. They had 3 children. Harry was reasonably successful. They owned a number of houses. Janet had developed a drug problem. She had worked at a doctor's office as a receptionist and managed to get her hands on prescriptions for strong painkillers, and she was using those every day. She was quite unreasonable, but Harry put up with that. One day or one evening, they had an argument at the top of their rather steep driveway. Janet became enraged and started hitting Harry. He gently held her arms to stop her from hitting him, but ultimately she broke free and ran down the steep driveway. She jumped at the bottom of the steep driveway and fell, and she sustained a very small scratch to her foot. She then ran off to a neighbour's house and the police were summoned, and Harry found himself the defendant in an apprehended domestic violence order application. He wasn't charged with assaulting Janet, and that was rather telling. And in addition, in the application for the apprehended violence order, the police included a notation which said, police are of the belief that had the victim been thrown down the steep driveway, she would have suffered more injuries than indicated. I required that police officer for cross-examination, and he agreed that that was still his view. The magistrate heard that and decided to reject the application because he simply could not believe that a person who alleged that she'd been physically lifted up and thrown down a steep driveway would sustain only a scratch. And he concluded that that allegation was entirely false. But Harry was denied access to his children for the year that it took for the matter to be finalised, and he was very lucky that he had another house to go live in, because he was evicted from his house by the orders made in the interim AVO.
Yeah. Now we should say, Harry, that you're not using their real names. These are disguised.
Yes, that's right. I'm not using the real names of any of my clients or the alleged victims.
Yeah. Well, see, that's the point, and he was very lucky that the police had commented on whether her injuries fitted in with what she was alleging. But of course, I mean, I think there's enormous pressure on police to just go with the flow. And we've heard this from men in this situation who get told by the police, sorry, mate, we just have to go with the system. You know, we don't really believe what's going on. I mean, police sometimes say privately to men in this situation that they don't believe the accusation, but they're forced to go ahead. And this is one of the points you made to me, Neill, is the police are required to take action even when they don't believe the woman.
Yes, that's right. I've not heard that the Commissioner of Police's standing orders to always pursue domestic violence matters has been withdrawn. They certainly behave as though they believe that they have to pursue them.
Yeah.
Unless they have good reason not to.
No, that's right. I hear from a lot of police. I've got a whole file of police who've contacted me who are really unhappy about the situation they're in, where they're required to impose unjust laws and make terrible decisions that are going to ruin men's lives. Now, what about Ian and Megan? I thought that was interesting.
Yes, Ian is a doctor. He's a surgical anaesthetist, and he was married to Megan for many years, about 15 years. They had 3 beautiful young sons together. Megan developed some very real psychiatric problems, and ultimately the pair separated. The 3 boys resided with Ian because of Megan's difficulties psychiatrically. But Megan started concentrating her efforts on alienating the children from Ian, and she in particular enlisted her friends and even the oldest son to make allegations against Ian. One day, the oldest son made an allegation that his father had assaulted him whilst he was at home with Dad, and Ian found himself the subject of an apprehended domestic violence order application. Concurrently, there were family law proceedings. They were proceedings which were finalised before the AVO application, and as a result in those proceedings, the family court judge specifically directed, most unusually, that his judgment be made available to the local court magistrate who was going to determine the AVO application. We then, the door was open to us to then use that judgment, in which the judge was very scathing with Megan, and we gave that to the police prosecutors, who, to their credit, discontinued the AVO application. But that application had been going on for 9 or 10 months, and Ian had been required to be constantly vigilant because Megan was constantly turning up at his house and making unreasonable demands and attempting to goad him into breaching the interim order. Yep. It's important to note that police officers, I don't think we can really properly make any criticism of police officers who are attending to these matters and police prosecutors. They're mostly all honourable men and women, but their hands are tied by the law and by their standing orders from the police commissioner.
Yeah, and a prosecutor who resists putting this sort of case forward, a magistrate who speaks out, makes any sort of comment in court about a false allegation, anything like that. We have this army of feminists out there and media who are, you know, part of this whole, well, I think it's a virtual conspiracy, if you like, to, you know, attack anybody who speaks out about what's going on here. And it's no wonder the magistrates are very quiet. They never make any comment about what's going on, do they? Publicly.
No, they don't. They don't want to. They don't want to appear anything other than impartial, and that's quite right and proper. And I think the police feel the same way. Although, of course, for the police, there's a very real danger that they can be disciplined if they don't do as they are ordered to do.
Yeah. What you mentioned in that with Ian and Megan, it was unusual to have that interaction between the family court and the magistrates court, and that is one of the problems. They exist independently, and there often isn't much connection between the two. I did a video last year with a woman who spent, horrible story, spent 7 years, her son spent 7 years battling in the family court with a very mother who was very disturbed, who threatened to kill herself and the children. And it took 7 years to get an amicable agreement about the father having reasonable contact with the children and so on. And they finally got it all through. The children were all settled down. And then she turned up at a magistrate court with new allegations. And it all started again. Yes. And you hear this all the time, that the magistrate, any attempt they made to say, look at this history, was just ignored in that circumstance. It is quite extraordinary.
Yes, yes. It's a pity that most of the time that kind of evidence, it's called tendency evidence, it is difficult to have admitted into court proceedings.
Yeah.
No doubt about that.
Now, what about Eric and Ellen?
Eric and Ellen were married only a short time, but before they separated. Eric was obliged to move out of his home when Ellen complained for an apprehended domestic violence order. He had to find somewhere else to live. She alleged that he assaulted her. And she was corroborated in that complaint by her friend, who we discovered had a remarkably long criminal record for matters of dishonesty and fraud. Ellen went to quite unusual lengths to incriminate Eric. She wanted him charged with breaches of the interim AVO. She used to turn up at his workplace and try to see him. She used to, on one occasion, she sent her.
I'm sorry, can I come in there, Neil? Because the point is, that's what's extraordinary about the breach. So the violence order is protecting the woman from the dangerous man, but she can actually put herself, turn up at his workplace, turn up at his house, and then he's alleged to have breached the order. I mean, you hear this all the time. It's it's a total no-win for the man, isn't it?
That's right. Well, if you have a look at section 14, subsection 7 of the Act, it contains an absolute immunity for the protected person who may attempt to aid and abet a breach of an AVO. Though they can do that they can engage in that kind of behaviour with absolute impunity. They cannot be charged or prosecuted for aiding and abetting a breach of an AVO.
Do you know why that is?
How could that? No idea.
Where were the lawyers? I mean, what has happened to our judicial system that this sort of legislation goes through without anyone saying, hey, that's not fair?
That's right. Well, the question in my mind is, where were the politicians who in our state parliament must have read the bill before it was enacted? They must have seen that section, for example, and they appear to have allowed it to have gone through. Perhaps there was strength in numbers. Maybe our politicians want to be seen to be politically correct and don't want to argue the point.
Well, the classic argument has been with my friend Augusto Zimmerman, a former law reform commissioner in WA, and he was, so the Law Reform Commission was given the task of examining this proposed domestic violence legislation, and he did a huge job recruiting people to say this is a really dangerous legislation. It will have terrible consequences. It's he made the case. It was totally inappropriate, and of course the premier, the politicians totally ignored all their advice, even though they had chief justices and God only knows who saying don't pass this legislation. And they'd appointed the Law Reform Commission to investigate it, and then they ignored their advice. I mean, it was just extraordinary.
Yes. He's a very qualified and eminent lawyer, and deserves to be taken very seriously, in my view.
Yeah. Anyway, let's go back to Eric. So we've got Eric and Ellen, and Ellen's doing her darndest to pull that over.
She even sent her son. They lived 150 kilometres away, but the son turned up at Eric's local Bunnings store and confronted Eric, and then she complained that Eric had breached the AVO by approaching a person with whom she had a domestic relationship. Eric was charged with breaching the AVO in relation to that, and I had to go to court and get bail for him the following morning. And of course, she was delighted that he had spent the night in the cells. He was ultimately found not guilty, but he spent
let me just mention that I love this, that so his house was car was filled with paint and smashed, and then she said her house was mysteriously burnt down.
That's right.
My God, this woman is a piece of work, isn't she?
That's right, a real piece of work. And it was so interesting. She removed every item from the house and sold it in garage sales. Even the light bulbs in the light fittings, the house was entirely emptied. And then the house was mysteriously set on fire by somebody. But a petrol can and a pair of women's shoes were found on the front lawn by firefighters. So she was a real piece of work. The arson was never pinned to her.
And so in the end, you managed to defend him, is that right?
Oh yeah, successfully defended him. I'm only telling you about cases where my client was ultimately successful.
I should think so.
And the allegations were completely false. But the point that I would make is that there is a preponderance of false allegations for AVOs in domestic matters, especially where there are concurrent family law proceedings.
Yeah. And you look at that case where it must have been very obvious to the magistrate that, some of you'd have to be crazy not to see some of this going on. And presumably you provided all that evidence. And yet there's no consequence. You get the AVO dropped against him, but there's no consequence for her, is there?
That's right. There's no consequence because complainants are represented for free by the police. It's impossible. To get a costs order against the police in domestic family law matters. You have less chance than a snowball in hell of getting costs against the police in those types of matters. And of course, complainants have immunity from prosecution for procuring, aiding and abetting. And there is no prosecution possible for making a false complaint in domestic matters. It's worthy of noting that, there's a section in the Act, Section 49, capital A, which criminalizes making a false or misleading application in a personal violence order. But there's no such similar section criminalizing false or misleading complaints in domestic violence matters. So there is absolutely no comeback on any complainant who wants to have a free kick at the spouse's head.
And of course, they argue that to have any penalty for false accusations would deter real victims from coming forward. That's always the argument, but it doesn't really stand up, of course.
It doesn't, because making a false allegation would be a very difficult thing to prove. It would have, though, some deterrent value for those who are seriously considering making a false application for reasons of their own. And there are reasons for making false applications. There are financial reasons. There are child custody reasons. There are all sorts of reasons for making false applications.
And, you know, the point I often make is when people are separating, which is often the case in these, this is where these arise, is,
Yes.
you're angry, you're irrationally angry, you're pissed off with your spouse. I mean, I remember looking at some of the psych research on how people behave in this separation process. And so many people report looking back on that period and feeling absolutely ashamed of how they behaved. You know, you're at your very worst. And here we are, hand women this an incredible weapon to display their anger to their partner.
Yes.
And now we're seeing the consequences of that. It's
We are.
quite
And it seems clear, I think, to most people that the price to be paid by innocent spouses is not so high that the system should be changed. But so it's important that we speak out about the abuse of the apprehended domestic violence order system in particular, because what gets measured gets done. What gets measured can be fixed. If we don't keep speaking out against it, then it won't be fixed.
Yeah, well, I'm very pleased you're brave enough to speak out against it, because I mean, you're lucky you run your own firm. You know, you're your own boss, and of course, a lot of lawyers are in that situation. A lot of lawyers are worried about antagonizing future clients and so on. There's good, you know, there's a good reason why a lot of people are very nervous to speak out about this. I mean, one of the things I showed you, Neill, was a recent submission by one of our big law counsel.
I think we dropped out.
To the we lost him. Hello, Neill. I don't know. What do we do, Robert? Will we try again? Hello. Oh well. Look, I'll just wind up. What I was just talking about was the fact that I was showing Neill this submission that's been made to an inquiry on violence, and here's this law counsel going on and on and on and on about victims of violence and the need to protect women and so on and so on. Nothing in that whole document about false accusations, when everybody knows this whole system has been taken over by this problem of false allegations, particularly in relation to family law. Well, I'm sorry we've lost Neill at this point. I hope you enjoyed my discussion with him today, and we need more people to speak out about what's going on here. Thanks very much. Bye-bye.